Hello, good afternoon and welcome to this, the second in a series of 4 conversations entitled Gendered Powers, Human Rights, Human Flourishing, Critical Reflexivity and Legal Norms is the subject of today's discussion. These conversations are brought to you as part of the Torch Humanities Cultural Programme, itself part of a founding stone for the new Stephen A. Schwarzman Centre in the Humanities, and as part of Torch, crucially as part of the Women in Humanities programme, itself led by our chair, Jane Garnett, fellow in history at Wadham College, and also academic lead for equality and diversity in the Humanities division. I'm delighted to be able to, that Torch is able to host this event here today, and I'm going to get out of the way, disappear from your screens, but return towards the end of today's discussion when I'll try and chair a question debate. So once everybody's finished talking, please remember that we will have question and answer session towards the end. Put your questions in the Q&A function, and I'll try and pick them up as we get towards the last third, shall we say, of the hour we have together. That's all for now then, and over to you, Jane. Thank you.
Thank you so much, Wes, and it's a great pleasure to be part of this this discussion. I thought I'd start off by saying a little bit about my own academic research as a sort of preamble to the general framing of the session. My academic research began in the 1980s with a doctorate on attitudes to economic ethics in England in the 19th century, which was a somewhat quixotic focus at the height of Thatcherism. The thesis addressed the respective role of legal regulation and of trust, and the workings of communities of trust in the construction and safeguarding of moral self-reflexivity. In a dynamic period of capitalist expansion, serious questions were asked about how the economy in the broadest sense should be conceptualized and framed. What was the relationship between growth and quality of life? Moral philosophical reflection on the conditions for human flourishing were both central and open-ended at this period. Victorian society was very far from the Wild West free-for-all of popular fantasy. This project in many respects laid the foundations for my own ongoing preoccupations with ethical agency and institutional critique, and with the importance of crossing disciplinary and cultural boundaries, to defamiliarize and to interrogate the often claimed universality of both disciplinary and societal norms. As Wes said, this is the second conversation in this series entitled Gendered Powers, which is intended to turn a variety of lenses onto what are too frequently taken to be timeless and/or context-free norms, and to think about the ways in which critical and intersectional thinking should be encouraged. In the realm of law, discourses of rights, capabilities, and flourishing are in dialogue and often in tension. How might cross-cultural and historical sensitivity and the foregrounding of gender, sexuality, disability, and racialization turn one-directional mirrors into refracting lenses, enhancing trust and respect for difference? We have a wonderful panel here this evening to engage in collective boundary crossing. The panel are all lawyers working in the area of human rights with a critical eye and a broad perspective. We have Helen Mountfield, QC and principal of Mansfield College in Oxford, who began as a historian, and I think once you've begun as a historian, that way of thinking never leaves you. We hope, as historians, we hope so in any case. Marie Tidball is a socio-legal scholar who has always subjected legal assumptions to rigorous scrutiny. In addition to their status as distinguished human rights lawyers, Hauwa Ibrahim and Cristina Valega Chipoco are both currently students on the MST course in Oxford in Women's Studies, a very interdisciplinary humanities degree, and they enact in their own persons their commitment to critical reflexivity. I'm now going to invite each panelist to speak for a few minutes, We'll then develop between ourselves some of the questions they have raised before throwing open the floor to general discussion. So thank you so much for participating in this event, and I'll turn now to Hauwa to begin our discussion.
Hauwa, I think you need to turn your microphone on.
Can you hear me?
Perfectly.
Okay. Thank you, Jane. Thank you, Pelagio and Wes in Women in Humanities, Touch, Oxford, co-sponsors of this conversation. Fellow panelists, class of 2021 cohorts, all of you that are in attendance that honor us with your presence. Happy International Women's Day in absentia. I'll run through 3 quick slides and I'll stop the sharing and I'll continue the conversation. This is the map of the continent. Okay. Something is happening. Can you hear me?
Yes, we can hear you.
Okay. So this is the map of the continent, and I just wanted to highlight the fact that the US, China, and India, and Eastern Europe, you can dip it into the continent and it still have some spaces for about half dozen countries in Europe and elsewhere. This is the map of Africa, which is 52 countries plus. And this is the map of Nigeria. I'll quickly highlight some few things out here. This is my country. The country is divided geographically into 3. This is the north, about 2/3 of the country.
Sorry to interrupt. Can you share your screen, Hauwa? We've lost the image.
Okay. Okay. So I don't know. This is not as easy for me. So I just wanted to go straight so that I don't take people's time out here. I wanted to share and allow you to see that 2/3 of the country is within the north, and that is where the difficulties of the kidnapping and the Boko Harams are. And somehow, if I figure it out, we'll see later. But I have 3 quick reflections based on our timing on human rights and human flourishing. English is my 5th language, so permit me if I murder English. Since coming to Oxford in 2020 October, I have engaged with complex ideas: gender, feminism, womanism, conflict, violence, as well as theories and concepts, bodies that matter, performativity, phenomenology, intersectionality, and imperceptibility, among many more. I have been enriched and blessed as an activist. With this enrichment comes curiosity, questions, doubt, and sometimes cynicism, and the role of law. And I ask, whose law? What law? Its application within wanted and unwanted bodies? And to that extent, I'm reminded of the fact that no doubt there is a universality of human rights to all people of all races and creed. But I guess it's more of the universality of human rights values and its relativism in culture and religion. There is tension in the issues of safeguard, promotion, and protection of human rights, as well as its normative application. And what came to mind quickly is the case of George Floyd in the United States, that the uprising of not too distant past. Secondly, I wanted to mention issues of structure and system, especially in developing countries with colonial history. So such structures and system at times serves as a continuum of challenges of human rights flourishing. I have read extensively since coming, and I always pay attention to research questions, methodology, data collection. And I ask, what is the quality of this data? Could we rely on this data? How much is the coverage of the data? And how are they constructed and later become policies at international and regional local levels? This become even more curious. Who set the agenda? Are there other motivations that guide such work? My journey thus far at Oxford has given me new vocabularies and concepts. We may be discussing some of them in the Q&A. But let me mention some: inequalities, power dynamic, power play, power relation, social change, gender equity, gender justice, gender operation, essentialism, construction, deconstruction, commodification, consumption, branding, advertisement, mouthful. The concept of human right and its flourishing is also wrapped in freedom and human dignity and liberation. Human activism could thrive where the paranoia of a dominant language of human rights is not detested by the same people it's being advocated for. The need for shared responsibility and agency is for us all, especially organizations with greater influence in some of our developing countries. In sectors such as the World Bank, World Trade Organization and its programs, the United Nations, when you think about the Millennium Development Goal and its move to SDG and the Agenda 2030, as long as these projects and programs doesn't deliver to citizens, and citizens find themselves sliding backward and insecurity prevail, it will be a drag on all of us. Where power gains are more toward cooperation, such as drug and food industries, information technology, the big one, religious fundamentalism, the future is less hopeful for activism. There is need to revisit reason, which used to be the prerogative of a human alone, the highest human faculty, which is now on trial, where it becomes passive, mainly downloaded in nano machines, such as algorithm, artificial intelligence. Yes, the new frontier. And it is increasingly used as a weapon and is making it easier sometimes for commodification. Indeed, passion shouldn't trump reason and hearing the challenges of human rights. And finally, the question of life, freedom, humanity, human dignity, and becoming is here for us to continue the conversation. One issue, one person, one day, one time. I invite our dear Cristina, an amazing young woman from Peru, to take over the conversation. Thank you.
Thank you very much, Hauwa. Thank you all. It's so very nice to be here. Thank you also for the invitation to Torch, to Jane, and to everyone involved. Today, I'm share with you 3 beliefs that I have regarding the title of this event about human rights, human flourishing, the role of law. I just want to begin by saying that, of course, I'm speaking from a situated and partial position. That's what why I'm sharing is as beliefs, because these are beliefs that I have. I may completely, of course, be wrong, or I'm also very interested in discussing these 3 beliefs with you. So the 3 beliefs that I have and want to bring to the table today are: the first one, law is interpretation. The second one, law must act structurally. And the third one, law is everywhere, but it's not everything. So to start, because I know we have a short period of time in this part, and then we're going to discuss more, I'm saying that law is interpretation because sometimes people tell us this cause you're fighting for or this thing you want to change is illegal. This cannot be done because there is no law, perhaps they tell us. And that is not necessarily true all the time. And as Jane has said, law is power. As Hauwa has said, whose law are we talking about? So the interpretation of law is an important discussion to enter, because traditionally, people that have had more power in society have not only sanctioned the laws, but interpreted them. And to put an example, in Peru, we have a case from a couple of years ago in which a judge ordered the Ministry of Health to offer for free the emergency contraceptive pill in every hospital in the country. Of course, I agree with this decision. And this judge contradicted with this sentence something the Constitutional Court had said before. The Constitutional Court had said that the emergency contraceptive pill should not be given for free by every hospital in the country because of a restrictive interpretation of the law. But since a judge has the ability to interpret laws, this judge, which was a first instance judge, way less than a constitutional court, said, I don't agree with that interpretation because of this reason and this other reason, and to better guarantee the fundamental rights of women in this country and of women that have less resources, we need to, and the Ministry of Health needs to give this contraceptive pill for free. So, of course, this was a process that had feminist lawyers behind it, but what I'm trying to say is that even though the Constitutional Court had given an interpretation, this judge challenged it because laws are to be interpreted and we can have different interpretations. And these interpretations can also be done by other people or by us in different spaces. For example, in a space within a university where a law needs to be applied, or when a policy is being discussed and some may argue that it is against the law, whereas others may argue that it guarantees human rights in a better way. From the university I come from, where I studied and I used to work in Peru, for example, we had one of these cases when authorities were discussing 5 years ago the trans reform in our university. That's how it was called. Because we were the first university in Peru to approve a policy that recognizes the identity of trans people within the university. In Peru, we do not have just yet a gender identity law or a gender identity act. So this was very important. But some authorities did not want this to happen. And they said, no, that is illegal. The university is going to be sued. But the trans students, and also Somalis, argued that it was, of course, not illegal. It was a policy that would guarantee in a better way the human rights, the right to identity and to be treated equal of trans people. And on the contrary to what some authorities said, argued that it was an obligation of the university to guarantee these rights. So yes, there are some interpretations of the law that have been made by competent authorities, and it is not that easy that we can just say, your interpretation is incorrect, mine is correct. Of course not. We need to have arguments and say them very rigorously. But also, when people tell us this, what you're fighting for is illegal, we can tell them that it is not that easy and fight an interpretation of the law that protects the rights of people with less power in society better. I think we can do that and we should do that. Because as I said, and as Hauwa was saying, whose laws or whose interpretation has been done up to now. The second point I wanted to share is that I believe that law must not remain in an individual sphere. It must be acted structurally. We need to move beyond the individual. The policies we are approving or states are approving and implementing, are these considering people in all their diversity? Are they becoming real and not staying in paper? Are they promoting the exercise of rights of people with less power in society? And to give you two examples, the first one, to combat violence against women, it is not enough to have judicial processes that are activated after a woman has been battered. Of course, they are necessary, but it is not going to be enough if we do not have other services, or states do not offer other services to protect women before this happens. Same thing with acts of discriminations. If we do not address the root of the causes of these problems, we are not going to change a society. For example, I ask you, if there were fairer job opportunities and different cultural norms in a specific society, would violence against women still be so high in that society? If there were a comprehensive sex education program in schools, would there still be the same levels of discrimination, for example, against LGBTQ people in some society? So it is not enough to have just processes activated or ask people to demand a judge to protect them. We need to act structurally, and states need to address the roots of this problem. And also, not only states, I think it's important to ask ourselves, what can we do from our positions? We don't need to be in high positions in the government to think structurally or to act structurally. What are we promoting within a university? In what areas are more resources being spent in? Or if we are in the MCR or in our workplace, what are we prioritizing there, and how can we make a change? I think acting structurally is very important. And just to end, my third point, law is everywhere, but it's not everything. We are people. What I mean with this is that laws are important, and we know that. We fight for laws, we need laws, because there are many laws and enforcement that are missing, mostly for people with less power in society. But we also know we're not going to change things overnight. And while we fight for new laws, more enforcement, better interpretations of the law, or better social policies, we must not forget the groups we belong to, the people we're fighting with, the people we're working with to change this. And I wanted to share this belief from a particular experience, because when I was working in charge of a free legal clinic that took cases of violence and of alimony, of people who did not have enough resources to pay for an attorney, it was very frustrating. The processes would take a lot of time, and even if we got a sentence in our favor, it was not easy to have it enforced. And there I learned that it was also very important to look the people in the eyes, the people that had their rights violated, to look at them, to recognize their human quality, as Hauwa said, their humanity, the one person at a time, to listen to them, to understand what they wanted, to listen to their story, and also to be truthful and tell them perhaps what the law in this specific case could or couldn't do, and the problems we were going to face. So I think it's very important when we talk about law that we don't forget that we are human beings, and then being a lawyer or doing our job, whatever the job is, student, a historian, a teacher, a professor, this does not mean we only have to do our job. We must not forget to be a kind human in the process. Thank you very much.
Hello, I'm unmuted. I don't know if I'm visible. Sorry, it was my fault. I thought I was meant to wait to be visible again, but I was meant to make myself visible. So thank you, Cristina. I found those very interesting and stimulating thoughts, starting from a presumption of human rights being about equal human dignity and respect and equal human right to flourish. Just to say who I am and what my background is for this talk. I am the principal at Mansfield College, where the Bonavero Institute of Human Rights is based, but for 30 years I have been a practicing lawyer, barrister in the United Kingdom, working on human rights and equality law. And having spent so much of my life doing that, I have to believe that law isn't just superstructure, the kind of residue of rules which show you how the power structures of society have worked and and crystallized, but that they have some normative and social effect and power. And I think that is right when you think about it in a historical perspective, and also over the course of my own career lifetime. If you think about how the law reflects who is valued and what the concept of equality before the law means. The concept of equality before the law has existed for quite a long time. The judicial oath in England and Wales is for a judge to promise to do right by all manner of persons without fear or favour, affection or ill will. And it's quite poetic language. But I think then the question is, well, what do we mean by doing right by all persons? What are the natural differences between them? You obviously send people who commit violent crimes to prison and not others. What are the natural differences between people? And 100 years ago, more or less exactly 100 years ago, actually, there was a series of cases in the courts in England and Wales and Scotland, which were known as the persons cases. There was a case against the University of St Andrews called Nairn. There was a case by someone born on the Banbury Road in Oxford, actually, Gwyneth Bebb, and the Law Society. And they were cases where women were asking to be admitted to traditionally male spaces and being told that they couldn't because there were laws about who could vote in elections in the University of St Andrews in the Nairn case, who could qualify to be a solicitor in the Bebb case. The legislation talked about persons wishing to vote or persons wishing to become a solicitor. So the litigants in those cases, who were women and feminists, applied for those rights. And in each case were told by the court that they couldn't, because although there was an Interpretation Act in English law that says that the masculine pronoun he includes the feminine unless the context otherwise requires. In both those cases, courts said the context obviously otherwise required, because if you examine the whole history of women voting or women or people who were attorneys, they weren't women, and therefore persons in that context must have meant only men. It took the First World War and the changes in women's place in the work during that time to lead to a statutory change, Parliament saying that sex disqualification was removed. The 1919 Sex Disqualification Removal Act said that women were persons and could participate in those professions. But it was acts of judicial interpretation that assumed that they obviously weren't. And the Lord Chief Justice in the Nairn case said no one could possibly believe that the legislation was intended to mean women. This was ridiculous. And then in the 1920s, Poplar Council, which was a left-wing London local authority, decided that it was going to pay women the same as men. And that was struck down by the courts, not a legitimate policy choice for a local authority to make, because the market showed that you could pay women less than men, and a local authority which was spending ratepayers' money shouldn't be paying more than the market rate. So it shouldn't be paying women the same as men. That was not seen as even a legitimate political choice for a local authority to make in that context. And if you move forward some years, when I started practicing law in the 1990s, there was a very small subject known as discrimination law. And discrimination law, although there were rules about discrimination in education and in provision of goods and services, cases were hardly ever brought. If they were brought in very hostile courts that didn't understand the subject. And the only people who really practiced in discrimination law were employment lawyers. So this was a kind of subset of employment law. And I'm afraid, according to the Oxford University undergraduate jurisprudence syllabus, it still is. That's the only way that undergraduates study equality law, is as part of the an employment law option if they take it. And I think that this is a very big problem and gap in our syllabus. And Marie Tidball, who's going to speak in a moment, has done some fantastic work trying to push for equality law to be more properly included in the syllabus. But the law, when it went to the English law, when I came to the bar, was the Equal Pay Act, which reversed the idea of Robertson Poplar, the case I was talking about, and said that women must be paid the same as men for equal work. And that was introduced partly when the UK went into the EU, because some governments in the EU, and the French in particular, were concerned that if there wasn't that law in the UK, then cheap British women might undercut a labour there. There was the Sex Discrimination Act and the Race Relations Act. So those were aimed really at very overt forms of discrimination, paying women less because they were women, the kinds of discrimination like in shop windows that you now see in period dramas about the 1970s, landlords saying no blacks, no Irish, things like that. It was about that kind of discrimination. But at the last minute, and as a borrowing from American human rights law, indirect discrimination provisions were introduced into those statutes that meant that if there was a rule that with which a woman, or in some cases a person from a racial minority, could not comply, that was the law, then that rule had to be justified. And the example was police officers who had to be 5'6" tall. And that discriminated against women, and it also discriminated in a case involving Liverpool police against people of Chinese ethnic origin, who were less likely to be able to comply with the actual requirement, you have to be this height. And if there was a rule of that kind, then the question was there justification for you for the rule being imposed? But the way that was framed was, here is the general rule, here are the norms of society. You, other person, claiming a right not to be discriminated against, prove that that rule is one that you cannot comply with. And there's a lot of case law about childcare when I first came to the bar. Well, can you literally not comply with a rule that requires you to work different shifts? Are you less likely to be able to do that than a man? And then if it is a rule with which you cannot comply, is it justified? Which sounds like a rationality standard. So it wasn't at all about whose norms society was built around or what you should be required to do, but whether you could comply with the norms as they were. That started to shift again over the course of the 1990s. There was a case that was based on European law, a very famous case called Webb and Emo, in which a woman came into a job to cover for another woman's maternity leave, and then she was pregnant. And the courts in the United Kingdom, right up to the House of Lords, which is what our Supreme Court used to be called, said that that wasn't sex discrimination because she was sacked because she couldn't work for the period of the contract, and a sick man would have been sacked if he couldn't work for that period as well. And the European Court of Justice said that was wrong because a pregnant woman is not a sick man. A pregnant woman, being pregnant is something only a woman can be, and being pregnant is not equivalent to being a sick man. It is about being a woman and needing some accommodation for that. And at around the same time, in the 1990s and during the turn of the millennium, there were other equality strands that started to be protected in British law, partly through the European law framework, but also through movements like the disability rights movement of the 1990s. And those really started, I think, to change the narrative framework and the normative framework that came with it. And gradually, I think the conceptualization changed from being anti-discrimination law, where the question was, can I show your norms harm me, to a more positive picture of pro-equality law. And I think it's quite interesting to reflect on how and why that happened. And I think there was a change which involved a shift from the idea of correcting wrongs to a gradual perception that rights are universal, that people should be treated equally, they shouldn't be punished for characteristics, for all sorts of characteristics, and that there's a positive obligation to protect, positive public obligation to protect rights. I think the disability rights movement was part of that because the social model of disability was so innovative in equality law, and in saying, I am not disabled because of my physical or mental impairment. I am disabled because of the combination of my impairment and society's refusal to accommodate it and to put in place the measures that would enable me to participate equally. And that is society's fault, not an act of God and something to be pitied. This is about a social model which society has chosen to make and which equality requires it to change. So that idea of reasonable adjustment and accommodation came, I think, largely from the disability rights movement. But it is very useful when you start to shift away from, can I actually comply with the rule that makes me work all the hours God sent, or could we adjust? The concept of reasonable accommodation, I think, is helpful for lots of kinds of equal dignity and respect. The other thing that happened in the 1990s was the Macpherson report into the terrible racist murder of a black teenager, Stephen Lawrence. And the Macpherson report famously concluded that the police in that case had been institutionally racist, not, they said, in the sense of being an organisation full of racists, or there were some officers where there was evidence of individual deliberate racism, but because they failed to consider their policies and practices and the outcomes of those policies and practices and the effect they had on particular communities. And the Macpherson report famously said it is incumbent on every public authority to think about how they operate, how that affects the people for whom they operate and on whom they have an effect, and to think about how they can change that to have a less discriminatory effect. And that led gradually to the public sector equality duty and the duty to have due regard to the needs to advance equality for particular groups. So shifting from an individual proving they had been done a wrong to public authorities thinking about what needed to be done to positively to promote equal human flourishing. And then the other thing that happened at around the turn of the millennium, I'm aware I'm talking from a UK perspective, but I think it's interesting to trace how these perceptual thoughts, perceptions of a duty to promote human equality and human flourishing emerged, was the introduction of the Human Rights Act in the year 2000, and therefore a big movement to educate all judges and lawyers on the European Convention of Human Rights and thinking about international human rights instruments. And at first, a lot of people said, oh, well, what we need is really the strong, very strong EU-derived rights to equality law of particular kinds. But I think the public sector equality duty and the equality guarantee in the Human Rights Act, which were seen as weak, were actually very normatively very strong, because the public sector equality duty is a duty on public authorities to give due regard to the need, described in legislation as need to advance equality of opportunity. And that requires public authorities to think about what the barriers are to equality of opportunity and what they could do to change it. And if they don't think about those things, they have failed to act properly. And I think that's a really big shift in the way the law requires people to think about what inequality is, how it's constructed, and how it can be deconstructed. And the equality guarantee in the European Convention on Human Rights, because it was seen as weak, partly because the case law was not so developed, and partly because it isn't an absolute equality guarantee. It only ensures equal enjoyment of the other rights that are guaranteed in the European Convention on Human Rights. But that is, I think, very significant, for example, in the context of welfare benefits, which are seen as a species of property for this purpose, because the duty in the European Convention is a duty on the signatory state to secure equal enjoyment of the other rights in the convention. And that's a positive and strong obligation if you interpret it properly, and it has been interpreted that way in the European Court of Human Rights in relatively recent cases. If a state has a duty to secure equal enjoyment of other rights, then you can take such a right and say, what is the inequality and why haven't you secured it? And that frames things in a very different way. So to take an example, there is a law that was introduced after the global financial crisis that said that social security benefits would be limited to only the first 2 children in a family. And the needs of third and subsequent children would not be taken into account to incentivize work. And there's a case that's gone to the Supreme Court. I don't quite know what's going to happen with it in the Supreme Court, but that would have been a policy which you may disagree with very strongly, but it would have been beyond legal challenge except on bare rationality grounds before the Human Rights Act was in force. But now it has been possible, and the way the case was argued in the Supreme Court was to say each of those children is an individual and their needs have been assessed by the state, and the state has attributed a particular right to property to people who have a financial need. But then it has excluded from any consideration for that right, third and subsequent children. That is a failure to secure equal enjoyment of whatever it is the state has decided people need when they are poor. And now the onus is to the state to explain why that is a proportionate thing to do. Why have you failed to secure that property right in an equal way? What are the countervailing values. Now, there's all sorts of problems with it, and I don't know if that case will succeed. We haven't had a judgment yet, but I think law can be really important in framing that kind of question. What is the right to education? What kind of syllabus do we have? And Cristina was right, I think, to say we can't do politics through law. Politics is broader than law. But what we can do is articulate and lock in political battles where theoretically rights have been framed in particular ways, but they haven't been enforced in practical terms. If we use the law to say these are the values which have been set down, which have been signed up to, and how can we now make those real? And I think, so I do think that lawyers then can be part of political debates about what it means really to create equal human rights and human flourishing. And I also loved the way that Cristina put it. Law isn't everything, but it is everywhere. And we do have to think about what it is to be human and what steps we need to take to ensure that everyone has the right to live a life that they value and in which they are valued equally.
Hi, I'm just making sure you can all see me all right now. Thank you so much to Helen, to Cristina and to Hauwa for their really fascinating talks. I'm going to really pull together talking about the nexus between human flourishing, focusing specifically on people with disabilities, though I hope there's analogous relevance for other protected characteristics too. Inclusive legal education, inclusive higher education institutions, inclusive legal profession, and inclusive legal norms in achieving social change and equal participation in society for people with disabilities. So that law affects and governs literally every aspect of human existence, speaks directly to why I chose to study law at Oxford as a wide-eyed 17-year-old. I understood then, as now, that law is power. To paraphrase Noah Feldman's article on why we need law schools, legal education enables us to ask the deeper questions about the impact of the law on certain sections of our population and interrogate whether the exercise of such power on these groups is legitimate. Asking these questions and learning about how this kind of power operates made it easy for me to choose my undergraduate degree and continues to shape my academic activism as the coordinator of the Oxford University Disability Law and Policy project. But having a physical disability myself has made it imperative to do so. A central tenet of the disabled people's movement is nothing about us without us, the movement that Helen spoke so passionately about. But one of the greatest challenges facing disabled people at all levels of the education system and in research on the issues that affect our lives is the need for our voices, our lived experiences to be included in the curriculum, in research projects and through our critical analysis as academics. Over 14 million people in the UK have a disability, yet this important demographic is largely excluded from the curriculum at every level of education and is underrepresented in our academic institutions. Children with special educational needs and disabilities face attainment gaps at every key stage. Disabled people face significant barriers in obtaining and maintaining employment, as well as facing a substantial national pay gap. Disabled people remain poorly represented in the legal profession too. Thus, while 19% of the working age population have a disability, only 4% of barristers identified as disabled. And worryingly, there is no data currently on the number of members of the judiciary who themselves have a disability. The coronavirus pandemic continues to present disabled people with significant challenges. Disabled people in the UK have died from COVID-19 on an unacceptable scale, representing almost 60% of COVID-19 related deaths. The anxiety disabled people have felt during the pandemic has skyrocketed. The United Kingdom's government's response to the pandemic has led to far-reaching changes to the law affecting disabled people under the Coronavirus Act 2020, affecting all aspects of our lives. Never has teaching and research on disability law and policy been more important in legal education. The case for inclusive legal education, therefore, is based on both a normative imperative for societal change for people with disabilities and a connected imperative for structural change of the kind that Cristina spoke about, but most specifically in higher education institutions and within their academic curriculum. This normative and institutional imperative for inclusive education are mutually reinforcing across all academic disciplines. However, inclusive legal education has a particularly and transformative role because of the relationship between inclusive legal curriculum, which analyses disability across the taxonomy of the legal system, an inclusive legal profession, and inclusive legal norms which shape our society. Thus, whilst feminist and race-critical legal scholars have produced numerous examples of how the law reflects the subjectivity of the white, dominant, affluent adult male, analysis from the perspective of disability theory extends these critiques of legal man to incorporate ableism as a key characteristic of rampant masculinist subjectivity. The role of disability rights activists, as Helen discussed earlier, on legal mobilization has had a significant impact on the development of equality jurisprudence and legislative change, including the Equality Act 2010 and the United Nations Convention on the Rights of Persons with Disabilities. Talk courses on disability enable a consciousness raising for all students, providing them with the tools they need by understanding these contexts and these critical tools to think critically about the application of their subject of study to issues affecting disabled people, and thus embedding that reflexivity within teaching itself. Inclusive pedagogical approaches make it more likely disabled students gain the skills they need to flourish in the legal profession too. This is why the Oxford University Disability Law and Policy Project and the law faculty are looking at more ways to include disability in legal curriculum here at Oxford. If we exclude disability from academic teaching and research, we exclude important questions about the impact of the law on the lives of disabled people. If we fail to remove the barriers to disabled people becoming legal academics, lawyers, or judges, we exclude disabled people from the decision-making spaces where we can interrogate and influence the exercise of power on our lives through our laws. The mutually reinforcing interplay between curriculum inclusion and barrier removal in higher education is not currently adequately facilitated by the leading higher education inclusion programme, Athena Swan. Whilst it is designed to drive gender equality and tackle the relative underrepresentation of women in senior roles in higher education, including in the social sciences and law, it does not even mention the intersection with disability in its principles or charter, nor does Advance HE's Race Equality Charter. Research evidence indicates that, consequently, other marginalised groups are unseen or lose out on key resources and input, and the Charter marks risk encouraging tick box or superficial change rather than achieving the kind of institution-wide or even large societal change needed in the HE sector and beyond to achieve better representation of all equality groups. There is no Disability Equality Charter, nor a charter for the other 6 of the 9 protected characteristics in the Equality Act 2010. This contradicts the spirit of the Equality Act 2010, which does not take a hierarchical approach to any of the characteristics it recognises. Further, the key areas recognised in the Athena Swan award levels fail to adequately integrate the imperative of departments to take steps to improve curriculum diversity and the iterative relationship between inclusive curriculum and inclusive higher education institutions. It is concerning, therefore, that there is little guidance provided on how best to do intersectional data collection and analysis, as Tsanaku and Pearce have argued. Thus, Athena Swan also stymies the perception of the multiple levels of exclusion within the academy and HE institutions of, for example, disabled people of colour, and how such exclusion might be tackled. When coupled with the dual workload of the Athena Swan Charter and the Race Equality Charter, the resource imbalance the Athena Swan creates between different marginalised groups has led some to conclude that a single equalities charter mark should replace the current gender and race equality marks. This would be preferable to the current situation and could better mirror the Equality Act 2010. In a way, the Athena Swan is an example of what Cristina described as law being everywhere but not being everything, and how we as academics therefore need to acknowledge and understand our own power to properly utilise the law and transform the inclusivity of the places and spaces of our universities. As back to notes in the higher education context, this raises questions for the institutional practices of the academy. Much more needs to be done by these institutions, including our own at the University of Oxford, to critically apply Athena Swan and better integrate the university's duties, including its public sector equality duties, towards all protected characteristics within the Equality Act. In particular, we need our academic allies within universities to better foreground the relationship between an inclusive curriculum and strategic programs to increase the representation of people with disabilities at every academic and employment stage within higher education institutions. Thank you.
Thank you so much, Marie. Thank you to all of you. I hope you're all going to now reappear in the, if everybody appears and unmutes themselves, that we can develop our discussion. Thank you so much. How are you there? There we go, great. Thank you so much. That's been such a rich set of issues raised and points to develop, which obviously, broadly speaking, I mean, revolve around this question, I suppose, that we raised at the beginning of universality in relation to particularity, of rationality, of how one defines these terms, and of how one, I suppose, deals with difference. And I was very struck, I wanted to bring us back, I think, in a circle, in a way, to where Hauwa started us off, with the question of ownership of legal approaches. Individuals, and Cristina picked it up with the point about needing to look people in the eye one at a time and to listen to their language. And Helen and Marie picked it up in terms of, I suppose, the question of different lived experience, and Marie's point about nothing about it, nothing about us without us. And the question of lived experience, I suppose, raises questions of life, but also of death, and of contexts where these questions, which might seem quite abstract, are hugely particularized and are matters of life and death. And how I wanted you to talk a little bit more about your own experience and about the very real tensions, I suppose, between different normative frameworks in the context you've worked in, religious frameworks, cultural frameworks, capitalist frameworks, and how those have actually, sharpened these questions, I suppose, to quite an intense degree, and how that might play through, problematizing our conversation, I suppose, a little.
Yes, at the beginning, I was very careful about the timing, so I didn't introduce myself. I have worked on the field. I'm more an activist. For over 20 years, I had been on the field, and my scholarship has been strictly Sharia the past decades that I've been lawyer. I started as a prosecutor and then ended up as a visiting professor in very many other colleges. Now, my hands-on work, which is still ongoing, one of the slides which I was unable to show, and I will try to see if I could show it now, is what I hope to I don't know if you can see here. Okay, so after my stay here at Oxford, of course, I'm going back hands-on and boots on the ground. The framework for advocacy for me include both global and local, and focus on the obstacle for women, girls, powerless, poor, voiceless, and the policies toward addressing them, and how we could bridge the gap between the relationship of the grassroots and the scholars and the political organizers, as well as demystifying the concept of theories as a practitioner. On the field, I had been defending women sentenced to death by stoning since the introduction of Islamic Sharia in Nigeria, and I was trying to show this map earlier on. Those dots on the map is the state where Sharia is being implemented in northern Nigeria. And in 1999, the law was, the Sharia criminal aspect of the law was promulgated to stone women to death and to amputate the limbs of children for stealing. And so that is where I sort of became more active in practice. In the field, I have discovered that when you talk about human rights and human flourishing on one hand, I also think about the power dynamic and the law itself. And when I started by asking the question, whose law, what law? And so we have to deal with that in the courtroom. I found that strategy and tactics are very important for the context in which I operate as a lawyer. Working within the fundamentalists was one way that was extremely helpful in our own case of the defense of women sentenced to death by stoning. And for the most part, the book I wrote, which is the 7 strategies for defense of women and children in Sharia court, is on Amazon. It was a bestseller when I wrote it in 2012. But for me, it wasn't important that it was a bestseller. What was important that right now the book is being used in the courtroom for guidance for judges, especially in the Islamic Sharia court. That for me is more important. I didn't write it for no motivation for money. I just wrote it because I thought it was important. And I wanted to end up by telling you one example of how I use Sharia to work within Sharia courts. So a woman was sentenced to death in 2001, and I was one of her legal representatives. I was the main legal representative. While we were defending the case, we had to argue issues of law, issues of fact, issues of procedure, and issues of technicalities. We fail on law, we fail on procedure, we fail on substance of the law itself. We won the case on issues of procedure, on technicalities. So it's important as we think about humanity and human dignity and human rights, how do we situate it in the space of practice, of hands-on, and in this case of this lady sentenced to death by stoning. When you fail in other places, where do you get your strategies to move on? 3 things I will say and I will shut up. The first is that for me, it was very important that we would learn to work within our dynamic. And our dynamic is multifaceted, multi-layered. How do we work within it? How do we work with the Sharia law? How do we work with the Sharia fundamentalists and the judges at the mullahs? And beyond working within the dynamic, how do we get solution inside Sharia? So that was one of the basic things that was very useful. And how we did that, and I give this example of how we use the sleeping embryo theory, which is doesn't make scientific sense, but it makes Islamic, one of the school of thought sense about the sleeping embryo theory, in how we argued that the woman was married before she was divorced, 11 months before she was divorced. So the pregnancy could have been the pregnancy of the former husband. So the pregnancy could have been sleeping. So we use the sleeping embryo theory to argue on technical ground. And because Maliki, which is a school of thinking that we practice in the northern part of Nigeria and the state where I was practicing, says a woman can be pregnant for a minimum of 6 months and a maximum of 5 years. So we're able to get within the same Sharia a way out to argue the case to get her freedom and justice and her dignity back. And we won on technicalities. And the last thing I wanted to say is part of the strategy that we use was not only paying attention to detail and being focused on the issues before us and not be sidelined, by the attraction of the media, which was out there when we were doing the case. How do we be focused and stay focused? How do we have plans A, B, C, D, and an exit strategy in our case because of the death sentences that I got during the case? And finally, how do we use the law creatively? I just mentioned one way to use it creatively, but I think contextually, there are many ways that we could always try to see how we can gain back dignity and humanity for the cases that, if we are in the field that we do.
Thank you, Hauwa. Thank you. Yeah, I mean, in a way, I mean, that, again, it elaborates the challenge that I think all these questions raise, in the sense that we live in a pluralistic global society within which there are very different conventions which different groups are operating under, and sometimes on multiple, people are operating under multiple conventions within the same society. And how, I mean, all of you have underlined the importance of the law in a sense being not just retrospective, if you like, but proactively constructive in changing cultures or helping to win trust in order to develop a sense of, I suppose, the changing nature of what is obvious, if you like. I mean, to sort of, so that the assumptions that people are starting from can actually develop. But how does one actually try to educate? I mean, I suppose how can an educational institution help to develop a way of connecting the global with the local and the particular, and the fact that in a global world in which diaspora is everywhere, if you like, people are actually multiple. They have multiple identities, they have multiple intersectionalities, and they operate according to many different conventions simultaneously, if you like. I mean, how can that be triangulated, if you like, within the context of law?
I mean, I think it's one of the reasons that a human rights framework is a very powerful one, because it starts from an assumption of equal human dignity and respect, which underpins a lot of different religious traditions. It appeals to a sort of 18th century Enlightenment tradition, and of course that's been interpreted different ways through different societal lenses. But there was some research from I think the School of Public Policy at King's London yesterday, which came out yesterday or the day before, which was really interesting on attitudes to different equality strands. And the vast majority of people, if you ask them, said everyone ought to have equal dignity, and it mattered if some groups were worse affected by the COVID crisis than others. But then there was an analysis of what other things people believed, what their party affiliations were, whether they were pro or anti-Brexit. And there were huge differences between whether people thought that disability or gender or race were issues that had been unequal, or characteristics, or where people with those characteristics had been unequally treated as a result of the COVID crisis. But people were, or whether they thought it mattered, but actually fairly universal perception that geographical differences mattered, which didn't seem to differ with party political affiliation or other values. And I think that sort of underpins that people do have a basic, quite strong perception of equal value and worth, and but they don't articulate what are the barriers to that equality. And it does seem to me that this is why things that require people to listen and to talk really matter. The human thing that Cristina was talking about, and that very powerful slogan from the disability rights movement, nothing about us without us. You know, that is part of the conversations, and taking a different equality strand, that are happening within the university when we look at racial equality, that there are people of colour, people racialised as Black, saying our voices should be heard, our perspectives and our narratives should be seen, but the responsibility doesn't lie with us. This is universal, this is important for everybody. So you all own it and acknowledge it as an issue, but don't decide what is going to be done, because everyone's, you know, this is part of the problem, that our perspective has been written out. And it does seem to me that that's why talking about human rights and human flourishing and equality of dignity and respect are really important, whichever equality strand you're talking about. And why I'm very attracted by Marie's idea about looking at not so much just what is the Charter for Racial Equality, what is the Charter for Gender Equality, but what do we do to have that sort of, I suppose, the Amartya Sen approach of what do we need for genuine equality of capacity to live a life that you value and to be valued for what you do. And I think that's the positive conversation that we need to have, and it needs to start from some values that cross other divides that we have about what we think is important, or how society functions.
That very quickly, just that I also think that education and from schools is very important. If we go to schools where we only see people that are similar to us, that have, I don't know, the same amount of money that we do, or the same, only the same color that we are, we're not going to learn that we are a diverse society. And I think that happens a lot, for example, in Peru, in my country, because if you have money, you can pay for a better school, better quoting, but you're not going to be in touch with different people or different children. So that's where I think also inequality begins, because we're learning not only rationally that we're only in a small group with people that are very similar to us, and not understanding that there are different people in the world that are in different situations, but also we're not learning emotionally that diversity is very important and is very enriching. So I think it's very important to promote these spaces in education, and also in universities, for example, right? Educate in law faculties that law is not only to learn about the laws or about how processes work, but also to understand the specific reality. If we don't understand the reality of our neighborhood or of our city or of our country, how are we going to be lawyers working for that country or for that neighborhood? So I think it's very important to get this from other disciplines and from reality itself. And I wanted to just answer one question that was in the Q&A that was asking about what I talked regarding law as interpretation. And the question says, if there's any way for law to be meaningfully interpreted on an individual level outside institutions. I really thank for that question. It had me thinking for a couple of minutes before this. And I do believe it is important to have institutions that have specific roles. For example, a parliament that gives law, and not everyone can give a law, and they're elected representatively. And also to have judges or a constitutional court. But I also think we can have an interpretation of law, and we can fight for it. For example, on the streets. I'm thinking about the abortion law reform in Argentina last December. Lots of people were protesting to have abortion legalized because they had an interpretation that it needed to be legal to protect women, people who seek abortion rights. So, and they had an impact. So even though the parliament and the Senate were the ones that sanctioned the law, people organized collectively can have an impact. And I do believe it's very important to organize collectively in regards to these interpretations, because it is the only way that different groups can be heard if we're not inside that institutions. So I do believe it's important to create the law from outside of the institutions, on the margins, as we could say it. But I also believe it is important to resignify the law from within the institutions, so that our interpretation, or the interpretation that guarantees human rights better, can be also institutionalized or established as a formal law. Thank you.
Thank you. No, I think there's certainly a responsibility, isn't there, which you're drawing attention to on institutions to do that, and on educational institutions to do that, but also to acknowledge, I guess, the history of these concepts in a way. I mean, Helen mentioned the idea of human rights being, in a sense, part of an Enlightenment project, and of course that, certain framings of human rights and human dignities are themselves, contextualized, and you're right that they can cross boundaries, but they need to be interrogated to check, in a sense, that they're crossing boundaries without imposing particular interpretations on or being seen to, which is Hauwa's point. That people need to feel ownership of these concepts. Yeah. And I guess there's a structural challenge there as well. In terms of, the intersection between the UN and local jurisdictions as well, in that sense. Yeah.
Yeah. But
I guess go ahead.
Sorry. No, you go ahead. Yeah.
I was thinking when you said intersection, Marie, I think you have not had the word, so I'll be careful not to go off so that you can come in as well. And what I found in my stay here at Oxford has been, like I say, a lot of curiosity and sort of bouncing back and forth. As I was trying to present, it was a little bit more dense, but I'm looking at the future for this human right and human flourishing, and how do we today be part of that future, rather than rethinking theories of the past. And I'm not sure that rethinking theory of the past is wrong. No, I'm not saying that. But how do we see what we have done? I've been on the field for 30 years. And it feels to me really heavy that I'm dealing with theories of 30 years. I'm trying to see how I could look forward and what else can I contribute in this forward. And part of what I was talking about, the reason and how we can now, as human rights and lawyers, and how we see the future from the lens of technology, because I think this is where it lies in the future. We cannot afford to be talking about Women's Month or Women's International Day or gender and development and what have you, without really deeper reflection. I agree with everything, whatever everybody said here, Helen, Marie, Cristina, about education, about, of course, Jane. But I'm just heavy in my heart with respect to moving forward. And yeah, Marie, please take it up.
Yes, you want to come in here.
So just a few responses to some of the really interesting issues that have been raised. So I think one issue Jane mentioned was around sort of how you get a closer relationship, I suppose, between the international perspective, the domestic or national perspective, and within institutions. And there's a really there's a useful piece in the realm of inclusive education that Peters et al. Wrote in 2005 about a disability rights in education model, which provides a framework to perceive the interdependency between implementing inclusive education at local, i.e. school or higher educational institution level, national and international levels. And so, for example, you know, the UN Convention on the Rights of Persons with Disabilities provides an international standard for inclusive education, but it nevertheless relies on national level policy and legislation for monitoring and enforcement. And in turn, individual higher education institutions must implement that inclusive curriculum, inclusive pedagogy and learning environments to actually achieve inclusive education in practice. But it's useful because it recognizes that action in one of those domains, or ineffectiveness or effectiveness in one of those domains, influences and produces various effects in the other domains. And I think you know, as academics, we need to be a bit more attuned to how the interplay or what's happening in those other domains, you know, affects our power within our own institutions and with our own disciplines. And that sort of brings me to the question around tensions that Jane mentioned earlier, and ownership of approaches and frameworks. And I think I absolutely agree with what Hauwa says about looking forward. And one of the things that we argue in the Oxford University Disability Law and Policy Project is that, you know, or I argue on behalf of the project very often, is that we've spent the last 10 years facing real challenge to our rights as people with disabilities through a decade of austerity, then followed by the Coronavirus Act, which really does have quite, in lots of ways, pernicious impact on the rights of people with disabilities. But so I think we both need to, in the presence, kind of acknowledge rationalities and strategies of governance which change the way those with protected characteristics are defined, and in turn how that then impacts upon our governance. And one example that I often give is around vulnerability and the extent to which vulnerability may obscure the rights of disabled people and our access to certain services, and that's been very much the case with the Coronavirus Act. Nevertheless, reflecting back on Hauwa's point, there's so much opportunity to expand our understanding, and I'm just giving the example of disability because that's the area I focus on, across the whole legal system. Whether that's looking at the regulation opportunity around regulation of driverless cars for people with disabilities, whether that's more inclusive care pathways for mothers with disabilities, or whether that's really understanding the tension in the intersection between environmental protection strategies, zero carbon strategies, and accessibility to our towns and cities for people with disabilities. So the future is ripe in terms of actually looking and understanding how and where the law needs to expand for disabled people. And I very much agree that there also has to be a future focus in order to be able to move forward and to really reflect the exciting opportunities that are there to improve the inclusion of people with disabilities, but many other marginalised groups as well.
So much, Marie. I know Helen wants to come in, but I'm afraid I'm going to cut you off so that we can actually draw in the people who've been patiently waiting and wanting to contribute off screen. So Wes, would you coordinate that, please? And
well, actually, there aren't all that many. And in fact, Christina's already responded to the first question. So Marie, your hand is still up. Does that mean you'd like to return? Oh, okay. Helen, so Helen, if you're I'm not overruling you as chair, Jane, but if your point follows on from the last one, Helen, do go ahead and I'll bring the next question in a minute.
Okay, I mean, I was just going to talk about the power of law to frame those obligations about the rights and duties we have, even without litigation, and particularly in the educational context, and what we think of as normal. And I was thinking of two cases in particular that stay with me. One was about a Sikh girl in Wales, Sarika Angel Watkins Singh, a lovely Welsh Sikh name, who wasn't allowed to wear her kara, her Sikh religious bracelet, to school. And the head teacher said that they couldn't be expected to protect her from racism, which her parents were complaining about, if she insisted on demonstrating her difference in this way. And there was fantastic law from the European Court of Human Rights, which the judge brought in, and I was very pleased, actually drawing on law from the South African Constitutional Court. That why should you suppress your difference to be accepted? There wasn't a reason. There was no rationale for preventing her doing this thing, which was culturally important to her. And it was in fact the school's duty to encourage other students to imagine difference and to know that different people had different ways of expressing themselves and different needs in that respect. And the other case that I'm thinking of is a case about a Muslim faith school in the UK, which went from 4 to 18, but from the age of 10, it was a mixed sex school. It wasn't a girls' school and boys' school, but it completely segregated girls and boys in corridors for sport, for lessons, for everything else. There was no difference in the quality of what was given to the girls. That was rigorously proved. There was no difference. They got as good teachers, they got as good results, but they were completely segregated within the school. And we brought it was Ofsted actually said that was an unacceptable way to run a school. And the Court of Appeal, the first instance judge said, well, just felt it was intrinsically natural that within one institution that was meant to be an all-inclusive institution, you could separate girls and boys because we have separate girls and boys schools. And the judge just couldn't see why that was not obviously different from saying we'll have black children in one room and white children in another room, or gay children in one room and straight children in another room, because it seemed natural to him. And when it went to the Court of Appeal, I said, well, no, because this is an individual right to study with other people. It's not about, it's about taking away that characteristic. And I do think that law helps us sometimes have a structure in which we challenge what feels natural to people and help them frame the need to change it. So yes, I agree with using international instruments in the way Marie was talking about to think about that issue.
Thank you. one of the questions comes in from Kathleen Quaintance, who seems to be one of your classmates on the MST. She says, Helen, you started as a historian, but also given that the others are sort of involved in an interdisciplinary course, what would you see the role of the humanities in your practice as law, any of you? And obviously I'm delighted with that question as the current director of the Oxford Research Centre in the Humanities. Anyone?
Well,
Helen first, yeah.
Yeah, well, I was just going to say that having gone from a history degree to studying law in a one-year conversion course in London, it was truly the most miserable year of my life. And it was the most miserable year of my life because it felt like learning the phone book. And they'd say, right, here's a contract, here's a horse, it was guaranteed to have 5 legs, it didn't have 5 legs, was that a breach of warranty? On you go to the next thing. And there was no normative content, there's no sense of why were these rules identified at this point? Why is it that people started to look at contracts in the 19th century and taught in the early 20th century and public law developed in the second half of the 20th century? Why these rules now? And I found that very upsetting and depressing. And I think I've been trying to get back ever since to why are these rules and whose rules and how do we debate them in that context and try and shift the context within which they're debated. And I was also thinking one of the cases about benefit cuts, the bedroom tax case, there was a very small c conservative judge who in the court, I was talking about the public sector equality duty and the failure of the policymakers to have thought about the impact, the differential impact of these rules on disabled people and saying this was a breach of the public sector equality duty. And just in the course of argument, it wasn't in the judgment, but the judge said, oh, don't be ridiculous. It's obviously just a question of rationality that no decision maker could make this kind of decision without thinking about the different impact on disabled people. You don't need a statutory duty to do that. And I didn't believe him. I thought this statutory duty has been on the statute book for 10 years and it has changed the way you think. It has just been shifting what feels natural to you, what feels, something that you couldn't rationally fail to do. So yes, I think that was, 15 years after the beginning of broad public consciousness of the disability rights movement in this country, and about 20 years after that and 10 years after the Equality Act was brought in.
Thank you. Hauwa, I see your hand is up on this question.
I think it's befitting for humanities and law to be in the same sentence for multiple reasons, because law deals with human and humanities itself, the entire concept of humanity and dignity of a human being is all encrypted into a system. And at times the system of law in most countries, developed or not developed, has always paved the way for development and for progress, sustaining sustainable progress. But having said that, let me piggyback a little bit about what Marie was speaking about, institution and the instrument that Helen mentioned of law and humanities in trying to reach an ultimate objective of fairness and justice in society. Ultimately, the entire concept of humanities is how we can have a just society where everybody has a space. And I was really thinking about what is happening globally in terms of the movement of justice and law. And in my presentation, I mentioned the transitional justice. So you have a concept of transitional justice in a lot of developing countries, where those transitional justice is more onto building of prison rather than building of classroom. I think the developing countries should be wary, because that will roll us backward. And as Cristina was saying, education, inclusive education is one way to think about moving forward and achieving a greater humanity and commonness among all of us.
You'd think after all these months, I'd know when to mute myself and not mute myself. We've got about 3 more minutes left. I don't know, Jane, if you, is there anything else that anybody wants to raise, either on the question of humanity more broadly, or humanities as an area of study, or I was very, if I may say, I was very struck, and a number of people have said this already, by Cristina's definition or proposition, third belief, that law is everywhere but not everything. And I, again, as somebody who doesn't study law but does study history and cultural history and so on, it strikes me that that's an interesting way to sort of frame much of the discussion actually that's gone on today, which is that, if you like, well, yes, law is interpretation. Helen's doubtless right, and Marie has talked about this as well, that legal instruments change the way we think about things, and what Jane said right at the beginning about changing what appears to be normal. I think that's a really interesting way of thinking about this. And you know, Hauwa's out there in the field doing that, as are others here. But also, yeah, who's normal is what in a sense was the question that was asked right at the beginning as well. So I'm not trying to pull it all together into one great lump, but I just wondered if anybody had any more. We've literally got about 3 minutes left. Has anybody got any more points they would like to raise, or any questions they'd like to ask? Cristina, I think you have.
I just wanted to say that I also believe it's very important to recognize that law is power, and that there is a dispute regarding power, because law has traditionally framed some understandings, and also has made some things possible and some other things not possible. And behind that is access to education. Behind that is people dying or living. Behind that is people, I don't know, having resources to be able to have a house, to be able to. So I think it's very important for us to remember that, because when I say that law is not everything, it's because it shouldn't be everything. But sometimes, and for some people or some groups, it is, because it means that they cannot have access to something, or others can and don't realize or see that as normal. So I just wanted to share that, and that I also believe that we as lawyers have ethical responsibilities too, because if we're working within a power dispute area or zone, then we're gonna be in one side, you know? And we can be in one side sometimes, in others some others. But I think it's very important to reflect on that too. What is our role as lawyers? Because law happens, but also lawyers fight for it. And so, yeah, thank you.
That's also where, I mean, obviously conversations within universities like ours, I mean, are important to probe from different perspectives, I suppose, the criteria by which that power is exercised, and that needs constant interrogation, doesn't it, from different, you know, points of view. So.
Yes, and I suppose you might think that that's, if we're trying to find points of connection between the humanities, broadly speaking, and the law. I mean, it seems to me that you've all been saying that law is necessarily engaged, and necessarily starts from somewhere and moves towards something, and whether it's again, you talked about this, Jane, initially being responsive, but then moving towards a kind of prospective, proactive duty. It's nonetheless an engaged duty of a kind. I'm not saying the humanities aren't engaged, but historians are, of course, and as literary scholars as well, where we're asked to sort of reflect on our engagement, but not necessarily simply reproduce a form of engagement in the first instance. So I think there's another way of thinking about all of this. I think it's probably time to wrap up, and in so doing, it's my task as the host, as it were, from this by way of torch to do so. But before I do, if I could just ask Jane, so the next two parts of this conversation or this series are next term?
Next term, yeah, absolutely.
Are they already, do we already know what they might be about?
I think we'll hold that in reserve. We're almost clear what they're going to be about, but
okay,
going to be great.
Okay, thank you. Well, we know that they will be in continuing celebration stroke interrogation of the 100 years of women here at the university in their kind of official capacity, as it were. That's one of the things that lies behind this particular series. And I hope that they'll continue to be about not only gendered powers and the way in which power, law as power, but other powers are gendered, but also about human flourishing in the way that you've all really richly described and analysed and thought about today. So thank you all participants for coming, and thank you all speakers for being here and for taking this discussion forward as generously as you have. Good night all, and goodbye.
Thank you.